Okay, it is noon, I think, on the dot. So I hope everyone enjoyed their lunch. I see a decent number of cookies. So, feel free to definitely get some sugar for the afternoon. Thanks again for being with us today. We are going to continue on our schedule. I know sometimes people might have to leave early. If that's the case, we understand. Please do complete the training survey and the pro bono attorney survey if you're able, and pass that off to Alyssa on your way out. Any questions on index cards, anything that you want to leave behind. And again, we'll be here after we end the training for any questions then as well. So if you have thoughts about those cases that are available, please don't hesitate to ask about them. And we're just going to go ahead and move forward. So Janie is a rock star. She's going to keep moving through today. Her name is Janie. You might see Sarah's up here somewhere. But we're going to talk about those 504 plans. Case A is a 504 plan case, even though we are usually dealing with IEPs. So the bus, I hope you didn't miss it. I didn't say anything. You had to really be paying attention. But we're going to go ahead and move forward with that next section of the training. Take it over, Janie.
Okay, Section 504. Section 504 of the Rehabilitation Act of 1973. So we don't see that many 504 cases, and sometimes it can be confusing because the lines can be blurred between Section 504 and IEPs. They shouldn't be, but sometimes they can. But Section 504, it's a civil rights law which protects individuals with disabilities in any agency, school, or institution receiving federal funds from discrimination, and establishes their right to have opportunity to fully participate with their peers. So Section 504, with it being a civil rights law, it can be not just for students in school. As we get into a 504 plan can follow a child into adulthood, and can be, because it is protects against discrimination, can be in different areas, not just the school setting. Section 504, it creates affirmative obligations for schools that accept public funding for students with disabilities of mandatory school age. It means that schools are required to provide a FAPE. It's the same definition as under IDEA, pretty much, but it's just the way you implement it is a little bit different. Well, the way it can be advocated for is just a little bit different. And then in DC, school is mandatory. As we know, school is mandatory from age 5 through 18. For younger students who attend a public elementary school, the regulations are less clear, but can be argued that they are also entitled to a FAPE under 504. 504 covers a student has to be determined to have a physical or mental impairment that substantially limits one or more major life activities, and has a record of having such an impairment, or be regarded as having such an impairment. Who is protected? A major life activity can include caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, or working. So what does the law require of the schools? That you provide a FAPE to students with a physical or mental impairment that substantially limits one of their more major life activities. And like I said just a minute ago, FAPE through Section 504 is generally defined the same as under IDEIA. So when are 504 plans used in practice? I like to think of 504 plans kind of like access. So let's say a kid has an allergy. They don't need specialized instruction. They have a nut allergy. They can't be in the classroom they need a nut-free environment. You might have a 504. They have certain foods that they can't have dairy as part of their lunch. That could be a part of a 504 plan. A child with ADHD who needs some sort of doodle or something to work to avoid being disruptive. The kid doesn't need specialized instruction to get there. They just need access so that they have the ability to do what they need to do. They need a doodle, but they're able to get their work as long as they have that accommodation there. A child in a wheelchair requires elevator access and bus transportation. You'd be surprised that I don't think it's so much an issue anymore, but it has been an issue where a child requires an elevator access in a DC school, and the elevators don't work in the school. And so the kid is not in class and is, being educated in a room by themselves because there's no working elevators. It's access to that enables the child to get their education services. Evaluations under Section 504. Evaluations are generally less comprehensive than evaluations. Parents have to consent to these evaluations. Reevaluations must be conducted before a significant change in placement, and reevaluations must be conducted periodically. The rules under Section 504 are they're less restrictive than under IDEA, and I guess overall give the parents less rights. So the content of the plan: regular education teachers and social workers can often implement 504 plans. They can include medical interventions, behavior interventions, accommodations, modifications, transportation services, like OTPT, specialized instruction, which I have not seen specialized instruction on a 504 plan, and I would be concerned about putting I would really question whether an IEP is really needed if a school is pushing specialized instruction onto a 504 plan, because that would make me wonder, does this kid need modification in their education and not just accommodation if they're getting specialized instruction? Is that specially designed? So you might, something to think about, because like I said, sometimes 504s and IEPs plans the schools can get that confused, and maybe they don't get it confused. Maybe part of it is that a school knows that if their child has a 504 plan, that's less work for them. They don't have to have a meeting they don't have to follow a meeting every, year, and there's less requirements from them. Yes. Mm-hmm.
So you talked about ADHD and you talked about a combination to do it all, but then it could also fall under the IEP. Mm-hmm. Is there an advantage? I mean, first of all, anybody ever do both? And number two, is there advantage one over the other?
Well, it just depends. If you have an IEP, you automatically get all the what you would get under 504. So you're protected under both ADA and IDEA if you have an IEP. So you get it. It's like a combination, but it's an IEP. But you get the services from a 504 that you would get if you just had a 504 plan. But it depends on what is needed. Like, for example, I had a case where a kid, this child, she's I don't even remember what her IQ was. Super high IQ, straight A's, just off the charts, brilliant. It had a pretty significant anxiety disorder and depression. So she didn't really need. She's outscoring everyone in class. And she was, I think she was like a ninth grader performing on like almost 11th grade level, but debilitating anxiety. And in that particular case, an IEP wouldn't have been appropriate because really she needed access. She needed accommodations for like taking breaks and having more time to do the work because she would get anxious and then not get work done. But when she got the work done, she was off the charts. She was, above average. So in that particular case, it made more sense to have a 504 plan than an IEP. Also, I will say, as far as determining whether it's a 504 plan or IEP, you want to look at what the evaluations say when making that determination. What's the recommendation from the psychologist? Are they recommending a 504 plan? Are they recommending specialized instruction? You want to look at what the needs are of the child to determine whether it should be one or the other. But I definitely, you want to, if 504 is on the table, you just want to make sure you know why. Is there a definite need for it? Do they need to have more, or do they need to have less? I mean, you also don't want to put a kid with an IEP if they don't need it either. So you want to make sure that if that is a possibility, that you examine if that's something that's really needed. There's no set team of people to develop a 504 plan. It can be parents, teachers, evaluators, school nurse, Parental consent is not required to implement a plan, but usually parents are included and ask for consent. Sometimes I will also add that, like I had a case where a kid, they had a 504 plan, but mom wanted the kid to have an IEP, and we wanted the kid to be evaluated, and they were like, "No, we're not gonna do the we're going to continue doing the 504 plan." I was like, "Well, in the meantime, just go ahead. We still want the evaluation." And they're like, "We're not going to evaluate." And we ended up getting independent. So the kids remained on the 504 plan until we got the evaluation. And then we came back and met and determined eligibility to see if the kid was eligible for special ed, which the child was. So legal protections, they must provide the parents procedural rights. They must have a dispute resolution hearing mechanism. That is, remains to be seen in DC. It can be an issue because I have never heard of or had anyone else talk about how disputes are resolved through with the 504 plan. Like if they're not implementing the 504 plan, you're like, you're not implementing it. There's not much you can do to resolve. I mean, you can file a Office of Civil Rights complaint, but that's not going to be anything immediate for a parent or a child. So disciplinary protections for children who are eligible under Section 504 are the same as for children who are eligible under IDEA. IEP versus 504 plan. With an IEP, the parent and child has more legal protections and more direct legal remedies. With an IEP, it's generally easier to get services in place. Schools often take the position that they are not required to provide services under 504. And that's because there's no federal funding for 504 plans, but there is funding for special education services. Sometimes schools will try to tell a parent 504 is the same thing as an IEP. It's not the same thing as an IEP. And as an attorney at these meetings, I've seen schools get very upset for telling the parent in front of them that no, it's actually not the same thing. So you want to make sure that those types of things aren't happening at meetings, but they do sometimes. So more information about for 504 and Section 504 plans, you can look at the Federal Department of Education. OSCE has also provided guidance to LEAs. So, group exercise. Your client is the parent of a 4-year-old boy who is in pre-K at a DCPS school. They are concerned because his doctor has identified gross motor concerns, and his teachers report that he has trouble getting up the stairs to different classes at a school. However, when your client asked about help at school, they said there's nothing they can do. What are your next steps? What options? What would you be thinking about going into taking on a case like this? Yes. Oh, did you hear that?
The IEP or the
Right. What would make you think, is there anything that would make you think one or the other more?
I would think 504. Gross motor skills are like walking as opposed to like pen.
Right. Exactly. Right. And that, as you recall, as we talked about, one of the things that was under the protected category was, does it affect walking or, so yes, and major life skills, walking. So yeah, that would be something that you would probably want to consider. Yes.
If you wanted physical therapy services, which would probably be pull out, would you want an IEP?
I think you could ask for physical therapy as part of the 504 plan as a related service if the kid didn't need like specialized instruction as a part of that or specially designed services as part of the PT. You probably could ask for it to be on the 504 plan. However, I would say you would want to get an you definitely would want to get this kid evaluated and have a physical therapy evaluation and see what the recommendations are before you decide which one. So, and also, we didn't talk about is evaluations. When you request evaluations, like I said, the parent doesn't have to say, I want this kind or I want that kind. But as an attorney advocating, you can say, one of the things that we're concerned about is, does this child need an IEP and what kind of services are needed? So you can be specific as far as asking like what you want to make sure that is evaluated or tested for. So, going on.
Can I ask a quick
Yes.
evaluation detour question?
working with families where the kids have suffered a lot of trauma,
Mm-hmm.
we see that it might be helpful because there might be a lot of stuff going on with this kid. To have a comprehensive psychological or neuropsychological where that person like really probably should have a PhD or a PsyD, like you said, can do that clinical component. The school is often default to like their master's in school psychology and say that person can do some social emotional testing too. How do you make sure that you're getting, an evaluator who has the right level of expertise that really is going to go deeper? How do you advocate to make sure that really it's more than just like a surface assessment of the kid's possible behavioral problems?
Yeah, well, I think, let me see the question is, how do you know how do you know that the evaluation is going to be done by an individual who is actually qualified, that is like a clinical psychologist, and they're going to, or they have the background to evaluate the child for their particular needs, like trauma needs and things like that, right? So I think that bottom line is you're going to still, like, let's say the school says we can do the evaluation. The school has a right to do that evaluation. I don't think you can get past the school doing it. You might know they're gonna, going in, we think, okay, the school's gonna do it. It's not probably gonna be, knowing that we're probably gonna ask for an independent coming after that evaluation. That's probably not gonna be what we're looking for. It's probably not gonna be comprehensive enough. The person's not gonna have the qualifications needed, but they still have a right under the law to do the evaluation. So let's say the school does the evaluation. It's a master's level school psychologist that does it. Most likely, when it comes back, it's not going to be, let's say I would be concerned. I would be surprised if it was comprehensive enough to hit all the things that you're the suspected disabilities that you're looking at in trauma, if they don't have that background. So I think that your next step would be get that evaluation back, and then you would ask for an independent evaluation. And if you disagree with what's in there, and I'm assuming that they didn't really capture everything, or they didn't really comprehensively evaluate this child in maybe the social emotional areas where they said that they would, and then you ask for an independent evaluation. And then when you ask for an independent evaluation, you want to try to find an independent, clinical psychologist that has the ability or has the background to assess this child comprehensively. So that's what I would do. Yes.
As a follow-up, how do you advocate to the school then that the child needs that test as opposed to the test that they did? If they say that their test was comprehensive enough, how do you go and you say, I need this clinical psychologist? How do you make the determination between the two? Like, what are some arguments that you can make to make sure that you're getting the right person to do that evaluation?
So your question is, how do you know whether the school psychological evaluation is comprehensive enough?
No. What if the school pushes back and says, well, you don't necessarily need clinical psychologists to do it? What are some things that you can say? Like, what is the delineation between the two people doing the evaluation?
So if the school pushes back and says, you guys, we did a comprehensive evaluation and we think that's comprehensive enough. And what would the argument be to say we still need a clinical evaluation? Is that what you're? Yes. I think what you would say, it would depend on what's in the evaluation, but ultimately, like, if they say, they can't say that either they can fight. You can say, look, we disagree with this evaluation. It doesn't have what we're looking for. It doesn't have, there's more testing that we think needs to be done. Without looking at an evaluation, there could be a lot of things that could be wrong with it that you might think we need to have, or we just disagree with what the finding is overall. We just disagree with this evaluation. So if you disagree with, like I said, the key is that you disagree with it. Once you disagree with it, the school you say, we disagree with this evaluation. We want an independent evaluation to be done. You ask for an independent evaluation to be done. The school has to give you that authorization for the independent evaluation, or they have to file a due process complaint against you. So the argument would come from, one, either give us it or you guys are filing against us. And if they don't do that, then the evaluation is, they can't just say we're not giving you independent evaluation no matter what. We don't care. We think it's comprehensive enough. They can if they file a due process complaint against the parent, but if they don't, they either have to do that or they have to file they have to either give you the authorization or they have to file a due process complaint. So once you say you disagree, I mean, you don't have to make, I guess, that many arguments. You can based on what you see in the evaluation. I mean, as the attorney, I would go through the evaluation and see what's missing. And I'm assuming that if a master's level did it, I'll tell you one thing that you won't see in a master's level evaluation is you won't see diagnoses. You're not going to see anything from the DSM. So if you're looking for like, does this kid have, explosive intermittent explosive disorder? You're not going to get a master's level psychologist can't diagnose. So those are types of things that you're not going to see. Probably one of the main things that you're not going to see. But also, depending on who does the evaluation, you're looking at, like, did they talk to the parent? What evaluations did they do? Did they get input from, how many different tests did they do? So there's a lot of things you can look at that you could use to argue against it. But the main thing is if you disagree with it, then they need to authorize it.
I guess as a follow-up to that, but then what if they're still, or like as the question was posed earlier, what if they're still trying to give another test, but you don't think it's sufficient enough, or it's almost the same level of testing that they've already given before?
Well, they really only get one bite at the apple. I mean, by law, they do the evaluation. We've had schools do that. They let's say they do the evaluation and they don't, and it's not comprehensive, and they're like, well, wait, we want to come back and do more. By law, they don't really get another chance. It's up to you. Sometimes we'll say, okay, fine, we'll let you do another evaluation because either parent doesn't want to do an independent, parent would rather just the kid just be at school. But by law, once they've done the evaluation, that was their chance to do all that they're supposed to. And I've made that argument at meetings when they're like, well, wait a minute, we did an evaluation, but now you said you wanted autism testing. We can do that. We can come back and do it. No, you already had one chance. That was your chance to do the evaluation. It wasn't comprehensive enough. We disagree with it. Now we want an independent independent evaluation. So they can say that, but you don't, by law, they're not really entitled to come back and keep evaluating over and over again. Really, that's your chance to say, I want an independent at that point. So. Mm-hmm.
So logistically speaking, when you give you an authorization to get a clinical, is that what pays the fees? Or does someone have to come out of pocket to pay for the clinical testing? Or does that person submit to the state? Or how does that work?
So the question is, what logistically house the payment for the independent evaluation, right? When they get the authorization. So the authorization in DC, you'll get an authorization letter, and it'll say like authorization letter, psychological evaluation, or whatever the evaluation, it'll have the amount that they're authorizing. So it'll say like $2,500 for independent evaluation. There's a whole packet that DCPS has, and charter schools, it's pretty easy to find out what theirs is. They don't have a packet, but they usually say in the letter who you submit it to. So you get the authorization letter. It'll say at the bottom who's responsible for authorizing it. And then there's a whole like packet of things of like where you send it. You send the authorization along with the invoice to DCPS, and then DCPS will cut a check and send it to the provider.
Is that something the provider does?
Yes. It's something the provider does. We only get involved if the provider's like, we haven't heard from sometimes we'll follow up, but usually it's on them to get it. And that is sometimes an issue in DC. Some providers will say, I'm not doing a DCPS evaluation because they take too long to pay, unfortunately. But there's providers that will do it. There's also providers that will do it pro bono as well sometimes. So, yes.
Do you have anything on your site that has access to who some of the providers are and if they do or don't do pro bono?
Yes, the question is, do we have people on our site that do evaluations and providers? And yes, we do. We have experts. We have psychologists and providers that do evaluations that we work with regularly, that we often will provide, give that information to the people that we're mentoring if it's necessary, and they will do the evaluation. So yes.